Live. I am George, founder of Solo, and this is the Debt Hotline. We have with us today Greg Anjewierden. Greg, how's it going?
Good. How are you?
Doing great. Folks, Greg is a licensed and practicing attorney. He used to work as a debt collection lawyer, collecting unpaid medical debt. With this experience, Greg knows all the inner workings of the debt collection litigation system and how it can be very unfair for people who can't afford a lawyer. Greg's also the founder and CEO of Debtbrief, a company that helps people who are sued for debt with consulting, legal representation, forums, courses, and other resources. Greg, thanks again for coming on the show.
Yeah, happy to be there. Happy to be
Yep.
here, rather. Sorry.
Fantastic. Greg, we were just talking about the holidays and the movie The Santa Claus, the beloved classic of Christmas. Did you get your weenie whistle this year?
Mine was the dating game. That's what I got.
You got the dating game. Perfect. Phenomenal. All right, folks. We are a hotline, right? So if you have any questions, you just call in at 801-613-8181. The topic that we're starting off with today is attorney Q&A on your next best move if you've been sued for debt. Greg, what should you do immediately after receiving a summons?
All right. So if you get a summons, the first step that I always tell people to take is to file an answer. Like that is the critical first step. I actually always tell people that they're probably better off filing an answer before they even try and call the other side. And I mean, even if you're looking at even if you're interested in looking at settlement, I would still file an answer. Obviously, a great tool is going to be, Solo Suit, using your tool to generate an answer. That's going to be a great way to do it, I think. But like I think the first thing you need to do is get that answer filed before the deadline.
Fantastic. And what is an answer? Is the phone call an answer? Is it just like answering your phone? Is that an answer?
So good
Or is it
question.
like,
An answer is like a formal court document. The title of that kind of document is answer. So you need to file that actual formal court form. And obviously Solo Suit helps you generate that document if you don't know how to do that. But essentially what you're doing is when you get a summons, there's also usually, in most states, there's also a document that comes with that summons called a complaint. And in that complaint, they're going to have numbered allegations, like numbered sentences that have the different allegations, them saying you had a contract, you didn't pay it, whatever. And you have to respond to each one of those allegations by either admitting, denying, or saying you don't have enough information to admit or deny. And so you respond to each of those, then you've got to file a copy with the court and mail a copy to the opposing attorney.
fantastic. Great. Yes, that's the rundown, folks. Yep. So if you've been sued for debt, you can use Solo Suit to respond to your lawsuit. You can also use Solo Settle to get that thing fully settled and wrapped up. Let's go ahead and start off with a pre-recorded question from one of our listeners. So this is Ron in New York. Or looks like hold on, let's make sure we get Ron here. It looks like we're gonna switch and go with Kevin. Okay, here we go. We got thinking this is Kevin that we're gonna be listening to. So let's go ahead and hear what he has to say.
Hello. Last November, I was being sued by Pressler via LVNV regarding Capital One, about $3,800. I answered their lawsuit, and then a couple weeks later, I received a questionnaire that needed to be sent in to them. How long do I have to answer them, and what happens if I don't? And what are the odds of being able to settle with Pressler? It doesn't look very good. Thank you.
Alrighty, Greg, what's your take on that?
Okay, so my understanding, he said he's being sued by LVNV, and it's
That's right.
Capital One, and he said he got a questionnaire. Now, I'm not entirely clear what he means by questionnaire. I assume if the lawsuit is already happening, then what he probably got is something like interrogatories or requests for production of documents, some kind of discovery requests. And then his final question was, what are my chances of settling? Are they pretty good? So the first thing I would say is if you've already filed your answer to the lawsuit and then you get a set of written questions from the other side, you have typically a deadline of around 28 to 30 days to respond to those. It's going to depend on your state, but typically most are about a month. If you do not answer those, you risk summary judgment against yourself. So they'll go to the court, file a motion for summary judgment and say, hey, we sent written discovery requests, they didn't answer those, so they're not participating in the lawsuit, or by not answering, you may have admitted certain things, and they'll ask for summary judgment. So you need to make sure that's done. If that deadline has passed and they have not asked for summary judgment yet, then you should still get your answers done ASAP, because the court might grant you some leniency on that deadline if you get those answers done before they file a motion for summary judgment. So that's the answer to the first part of the question. The second part is, how agreeable might they be to settlement? I mean, I would say there's like a very good chance that you could settle this case. I obviously don't know all the details. It's $3,800. What I don't know is what it can settle for, right? Because my experience has been, and George, you help with a lot more of these settlements, so you may have data that has better information than me. But like, can it settle? Yeah, absolutely. Will it settle for a number that you can do? I don't know. At least at this time, my experience is sometimes if you try and reach out and settle initially, it doesn't get done. But if you can engage in the court process and like keep working, like eventually most cases are going to settle if that's what you're trying to do. But I don't know if your experience with LVNV specifically is, if you have better data on that, I guess.
Yeah. Yep. So, we see a lot of cases. We see, a lot of people use Solo to resolve their debt with Pressler. That's the law firm. And then LVNV is going to be the debt buyer, the plaintiff in this lawsuit. We see people resolve with both of those players quite a bit. Oftentimes, folks like LVNV, they're a large debt buyer and collector. They're like one of the 3 biggest in the US. So they have a pretty routine collection and like settlement process. So they're going to take things like less personally than sometimes like a small little player might. And yeah, we see a lot of debts settle with both of those folks. Yes. So yeah, certainly Kevin, right? Step 1, respond to the lawsuit using Solo Suit. Step 2, send over an offer to settle with Settle. And that's the play. Doesn't hurt to make an offer. There's not much downside, or really any downside. It's free to make an offer. You aren't tied in unless you get a deal that you like until you sign like the document for the settlement. And settlement communications aren't supposed to be used against you or anything if you go to trial or if you decide not to settle. Yep. So it's a little downside. All right, folks, this is the Debt Hotline. If you have a question, call in live at 801-613-8181. And that's how you skip ahead to the front of the line. We have a lot of questions from people written in ahead of time. We have One from Jeff in California. I was sued by Discover. I settled and signed the settlement agreement stipulation 32 days ago. The law firm has not returned a copy with their signature. They also have not recorded the stipulation with the court. Is there a time frame in which they must record it? Thanks. So how about that? Is there a time frame for settlement to be recorded?
So they've discussed and reached what they think is a deal. There's a signed stipulation. This person has signed it, but the creditor has not signed it and given it back. So there's a couple of things here. I think you should always assume that your case has not been settled until you get the signed stipulation back from the other side, right? So like I would continue operating as if the case was going to trial until then. So if there are things, deadlines or things that you have due, discovery responses, an answer maybe, like you have to assume that until you get the signed stipulation back, that there is no deal, right? Now, there are some, I guess, nuances here. Like if, for example, you went to a mediation and at the mediation you reached a deal, usually at the end of a mediation, the mediator will do like a mediation statement or something like that will kind of outline the broad terms of the deal, but then say the parties will get together and finalize a settlement agreement. If that's the case, then what I would do is like file a motion to enforce settlement and tell the judge, hey, we had a deal and they're not following through with that deal. And I'm asking you to enforce that. But again, until that is decided, I would assume that there is no deal done. So for the most part, the other fact of the matter is probably what's happening here is they're just busy and your case isn't important and they just haven't gotten to it. So like the other thing you can do is just call them and say, hey, I sent my signed stipulation back and I don't have it back. And they'll probably be like, sorry that, we just haven't got to it yet. I mean, that's the most likely scenario.
Yeah. Yeah. Some thoughts that I've seen that, some insights that may be surprising if people aren't that familiar with the space. Jeff, oftentimes settlement agreements don't need to be signed by both parties, right? So a lot of collectors will use agreements that are just signed by one party, just like by the consumer. More frequently, like pre-litigation, before you're sued, you'll just get a settlement letter that isn't signed by anybody. It's not signed by you, not signed by the collector. I think best practice once there's a lawsuit is it should have a signature field for both you and the collector. But then oftentimes, collectors, in our experience, collectors really don't have it as part of their process to return a fully signed agreement. As far as they're concerned, they just need this agreement from the consumer. It just need to be signed by the consumer. And they oftentimes don't have it as part of their workflow to return a copy that's signed by them, surprisingly, because for understandable reasons, you want that in your records, for sure. And you definitely should get that, and they should provide it to you.
I agree with you there.
Yep.
They don't care. They want to get the money. So you sign it and you've promised to pay the money, and they don't care about signing something else. I do think if you're reaching a settlement, you need to, as part of your negotiation, get a signature from them, because they should be promising to do something as part of your settlement. And that's something that they should be promising to do is if there's already a lawsuit filed, they should be promising to dismiss the case with prejudice. Or if there's already a judgment, they should be agreeing to declare the judgment satisfied.
Right.
Or promising that they're not going to come after you for the rest of the balance above what you've promised to pay. So that's why it's important to get a signature. But I agree with you that they just don't always care about doing that.
Right. Well, and Jeff, where the rubber hits the road, where you can get into a tight spot, is what is the first payment date on the settlement agreement, right? So if, this was 32 days ago, you signed the agreement on January 1st, and then the first payment date is January 31st, but January 31st rolls around and they haven't returned a signed agreement to you. What do you need to do? That's a little bit of an interesting spot. I mean, signature law is really pretty interesting. People really freak out about signatures. What do you think, Greg? Is there an agreement? Is there an agreement if they haven't returned a signed agreement?
I agree with you. You're kind of in a vague area. The way to avoid this problem is to make this part of your negotiation of the settlement. I think most people get into these negotiations and it's all about the dollar figure, right? How much are you going to pay and when are you going to pay it? But part of your negotiation should also be, what are they going to do for you? And what is the form of your settlement agreement? So, like, I know you're in this problem now and it's a little too late, but for other people, you should be thinking about all these things when settling the debt to avoid this problem. Now, if you're already in that situation, what you can do is you can, take there's a calculated risk here. Do you just make that payment and assume there's a deal done? That maybe there's confusion there or they disagree on things and you might be out that money if you do that. The other thing you can do is go to the court and ask for clarification. File something with the court, like a motion to enforce settlement that says, hey, we think there might be a deal here, but there is some confusion around it. So we need the court to determine whether there was actually a deal or not. That's something else.
Yeah. And since this is a stipulated, so in this situation, he's getting a settlement agreement. And part of that settlement agreement is a stipulated judgment saying if he doesn't come through on the payment plan, then he agrees to a demotion. He agrees to default judgment again, or he agrees to a judgment against him, at which point they can garnish his wages, right? That's basically the body of a stipulated agreement most of the time. I think he'd probably be in a pretty sound spot to say that if the first payment date is January 31st and it's now February 1st and the agreement hasn't been filed in court, that it's void, right? Even though he signed it.
Right. Now, here's the other thing. Here's the other thing you can do. There's nothing that says that you can't file the stipulated judgment in court, right?
Interesting.
You could just go ahead and file it. And if they're going to say, hold on, that wasn't our deal, they're going to have to file something that says this is not our deal. And my guess is that they have the other side, the creditor, has drafted that stipulated judgment. What are they going to do? Show up and say, this isn't accurate? So that might be another way to do it, is you just go ahead and file it and make your payment and assume that everything's moving forward.
Yeah, that's a pretty good take. Right? He could just file it himself and then make the payment, especially if he's getting like a good deal and he just wants to get this over with.
Yeah.
All right. We have Nibble calling in. Let's see. Let's go ahead and plug you in. Let's see here. How's it going? This is George.
Hi, George. This is Nabil. Can you hear me okay?
Yep. Your name's Nabil, you said? Nabil?
Yeah, Nabil, like an automobile. Hi, how you doing? I'm on your email list. My first time here. I'm in Jersey. I'm calling because I'm disabled. I have cerebral palsy in a wheelchair, and I have some credit issues. A couple that I spoke to the lady about. Number one, I'm paying a credit counseling program for about 2.5, 3 years because where I'm paying like one lump sum. I have a lot of charge-offs from helping family, and the interest was snowballing, and also like over the years, like paying bills and car repairs, and just the interest was drowning, and family never paid me back and nothing. And then so I have the charge-offs. They sue on my paycheck, where they take a percentage every 2 weeks, and they're all just standing in line one at a time. But I'm also paying voluntarily to the counseling program. But then also I have other issues where like credit repair companies promise deletions, $100 a month, piggyback companies in Florida when my credit was top notch 5, 6 years ago, 8 years ago. And then I got like credit repairs talking about usury laws. It's too high in New Jersey. Then they're talking about Rothman, where like one credit repair attorney saying that one creditor was wrong illegally, and then paying that guy, then following up with him and then another attorney telling me that attorney was not doing it right, and then he went out of business. So I have a lot of complex issues, even like my creditors. I have like credit report. I check. I have like weird addresses. I make disputes, or I'm like saying disputes. They always deny all my disputes. So it's like I've been up and down this road for the last 15 years. Or I'd be okay. I'd spend a little bit, help out, life, and then you know, it would tank and then people wouldn't pay me back. Then I would fall behind. Then it would slowly build up, you know. So I've been around this thing 3-4 times in 15 years or so, you know, give or take, since early 2000s, you know, and, you know, I'm still paying out of my paycheck. I'm still paying the program, and I'm still, you know, looking into. I have old files I can maybe show you guys, and a lot of different complex issues. And you know, they slowly worked on my credit. My credit's shot. It's in the 500s. It used to be 700s. I am getting lowballed credit card offers, $1,000, $500, 700. So I'm slowly building myself up again. But this is where I'm at.
Great, Nabil. Thanks for sharing.
You're welcome. You're welcome.
How's life in Jersey?
Great. I've been here all my life, and you know, I take it one day at a time, George. You know,
Nice.
So
I like it.
I appreciate it. You know? Yeah.
Yeah, sounds great.
Sorry, my phone. Let me just hang up the phone. Sorry about that. So yeah, that's my story. You know.
So, what kind of income are you working with?
I am.
We lost your audio. Your audio got.
I'm working.
Okay, there it is.
Oh, okay. I was.
Say that again.
I was full time. Can you hear me? Okay.
Yeah.
Okay. I mean, right now I'm working part time because of some medical issues, and I'm sorry about that. The phone was ringing. Okay, can you hear me? Okay.
Yep, we're hearing you now. Yeah.
I'm working part time because of some medical issues.
Oh, lost him. Nabil. Hopefully, you can join again. Did you have any quick thoughts on that, Greg? Sound like you.
So
a lot of stuff going on.
Yeah, here's my thought. It sounds to me like he really actually has two issues that are similar but need to be treated separately. So, I think this is like a really common thing that I see when I meet with people is they talk about like, well, I'm being sued, but it's been charged off, whatever. Like things when you're talking about credit repair and you're talking about like wage garnishments, which sounds like he's got some of the issues of both. Like those are similar things, but they're unrelated. So when you're dealing with a wage garnishment, it really doesn't matter what's on your credit report. It doesn't matter if that is on your credit report incorrectly. It doesn't matter if it's not on your credit report. Like you've got to kind of, if you're trying to improve your credit and you're trying to settle these debts, you've got to kind of treat them separately, right? You've got to deal with the court issues with the court. You got to deal with the credit repair issues with the credit bureaus. You know, as far as like, oh, the account was charged off. Again, if you're dealing with court issues, that doesn't really matter. Like if a creditor is charging off a debt, writing off a debt, selling it to a third party creditor, you know that is courts don't care. Like that's not part of the evidence that's going to be meaningful in court. So, I mean, he's got this long line of garnishments. What I would say is, you know, if you can still afford to pay these garnishments, maybe I would try and settle some of them or just let them, you know, continue to garnish your wages if you can afford that. And then your credit's already bad. If you feel like when it gets to the point where you can't settle all of those and it becomes so overwhelming, your credit's already bad. So that might be the time to think about bankruptcy. So those are some of my thoughts.
Looks like maybe we've gotten Nabil back. Nabil, you back?
Oh, yes, sir. Yes, I'm sorry about that. My bad connection. Let me just shut the computer off.
Nabil, so Greg was just saying that you have two issues, right? You have a court issue and you have a credit issue. So one, you got to deal with the court stuff. In court, you got to deal with the credit bureau stuff with the credit bureaus. Yeah, that's the main summary.
So I'm sorry to interrupt, guys. So I am installing the credit counseling program. You know, and they're still garnishing my wages through the courts. I mean, apparently credit counseling companies can't touch the wages garnishments because they went to the courts, but I am making those payments every 2 weeks, and I'm paying the monthly counseling program for, I think they said another year or so. By the end of the year, I'll be clear by November, December of this year, after about 3-4 years. And, you know, and then but I don't know. I missed what you said there, sir, because of the phone connection, and you know, people, family call me and they didn't know I was, you know, they're always checking on me because of my medical problems. But the point is, back to the credit stuff. The credit repair companies. I mean, I'm paying $100 a month for monthly deletions and that, and then there was another one. One was credit standard scores. I'm in that one. Another one I was in was benefits. You know, LLC. You know, or they were same thing, making they would promise dispute letters, and then the creditors, the TransUnion, they would just go back and forth for 2-3 years. So I gave up on benefits, and then I don't mean to blast anybody, but this is my own personal situation. I don't know if I'm not blasting anybody. It's just my own situation. And then you know, the attorneys saying that, and then the other attorney went bankrupt and had a business with the other attorney said that credit repair attorneys, Rothman and Roth, something about so I have letters I can email you guys. I keep all my files over the years.
Nabil, something I was curious about. You said you had a disability of some sort that you've been dealing with?
That's correct. Yes, sir. And I'm dealing with
Oh,
disability on the federal and the state because of my job changing. I was working too much, and then you know, and then I got hit by, and now I have a brain injury because I got hit by a car in April. So now I had my doctors only cleared me to work part-time, 1 or 2 days a week. I'm in Section 8, thank God, 7-8 years, you know, knock
you
on
say
wood.
you
know,
said you were dealing with palsy of some sort, or what was the disability you said?
cerebral palsy, and more recently a traumatic brain injury from I got hit by a Jeep in April, but I was born with cerebral palsy all my
You've been
life.
working through this. You've been working through all this. I mean, it sounds like people are. I mean, to me, like,
for the last 15 years, I do
congrats
disability,
to
not nonprofit work, you know. But
right. Well, I mean, congrats to you for working. Congrats to you for working. It sounds like some people are relying on you in your life as well, and notwithstanding
yeah,
cerebral palsy, which I think could be, you know,
yeah.
quite a significant factor. So, congrats to you for working. It sounds like, you know, just wrapping up, Nabil. Thanks for calling in.
Sure, yeah, no
And
problem, man.
yeah,
You
it
know,
sounds like,
thank
you
you
know,
guys.
main two things that you just want to wrap up this garnishment in court if you can. If you never responded to the
Mhm.
lawsuit, you can do a motion to set aside judgment, and then the
Um,
credit
can I,
issues, you know, you can send
can,
dispute letters to get them off of your credit.
well, motion is just, can I ask you a question, George?
Hmm.
Like, one of the credit repairs company told me, don't ever go to the court with the creditors. You always lose. Always let them go by default, which I never went because I was scared. I'm thinking like I'm gonna go to jail for a credit card, you know, and because of non-payment. But I was in debt. I have medical, financial problems, and just life hit me. And then so was that right advice when they said don't ever go by default, let them default you, number one, and then number two with that. I don't even know if they take it off my report, or sometimes I think they double charge me. Like, how do I know I'm not paying on the paycheck on one side, then on the left side I'm paying the counseling monthly program? And how do I know they're not paying? And then Amex is calling me, but I paid off Amex already. It's like, and then I heard like they reset the clock, and so I'm like, I don't want to pick up the phone, but what if it's a repair or counseling or a lawyer or a doctor? You know, so it's like my credits just, the report looks terrible. I'm trying to clean it up and pay off everything, but like even Milestone and like what was it, Capital One, they would on a month to month basis they would send me delinquent not letters but like emails, notifications saying that they restarted it for the month of like February 1st, then March 1st, and every month they would say, because I was behind from like the original maxed out amount, because you know, I was overwhelmed and I stopped making payments at a certain point
Right.
when I was just drowning. Now I'm in the cleanup phase. But like, what
Okay.
about like the reset? They're calling me, they're emailing me saying that it's renewed, the delinquency is renewed. And what about the company saying they
Okay.
could delete stuff? If I pay $100 a month,
Greg, what's your
you know,
take on the court issue with the credit bureaus? Do you have a take on that? And then we got to get on
Yeah,
to the next caller.
I mean,
sorry. Thanks,
my
guys.
experience has been there are some credit repair agencies and people that do credit repair that do a really good job. I think it's kind of an industry where like there's people that don't do as good a job too. And you know, it kind of depends on your specific situations. Like I'm an attorney, right? Like I am going to engage in the court system when it presents itself. Like I generally think it's not a good idea to just let stuff go to default judgment. Because it's you know, I understand the theory there. A lot of credit repair people, I guess, ascribe to this theory where like, don't do anything, make them come after you, and in the meantime, we're going to save up some money and try and settle these as they come. I take a different approach. I'm not saying I'm right necessarily, but my approach is you get sued, file an answer, avoid the default judgment, and then try and settle them one by one as they come into the court system, right? And so the ones that you've got in the garnishment, I would try and settle those ones first. The higher priority, you said there's a line, obviously. The first one gets to garnish your wages, and then the second in line and so forth. I would take those one by one, try and settle those if I can. Again, if it becomes too overwhelming where I'm just like, I'm never going to do this, at that point, I would probably consider bankruptcy. And then, so that's one issue. The other issue is credit repair. I would engage the credit bureaus, send those, you know, dispute letters, whatever, but that's going to be a separate process than dealing with the issues.
Great. Nabil, thanks for calling in. Happy to help you out. All right, Sean, we have Sean calling in next. Folks, let's go ahead and hear from Sean.
Hey, good afternoon. Hopefully you guys are hearing me loud and clear.
Yep, we can hear you. We can't see
Right,
can't see you, but we're hearing you.
beautiful, beautiful. All right, so the situation is I'm enrolled with a debt relief program, and one of the enrolled debts, I got a summons from their attorney. That program has sent me a partner, like a legal partner. That legal partner did reach out initially, but now they haven't given me any next steps. And I'm about 5 days away from the due date of responding to the summons. So my question is, because I've tried to reach out to them, we had 20 days, we're in the state of Florida. So the question is, do I do a Hail Mary and just go to the court and file a response, or call that attorney's office, that the plaintiff's attorney's office, or sit and wait? Because I don't want them to get a default judgment.
All right, Sean. So just recapping. So you're in a debt settlement program. Who are you working with?
FDR, Freedom Debt.
Okay. Yeah, so the biggest one of the biggest debt settlement firms. You've been sued for a debt, and then you were sued for the debt, right? You weren't sued by FDR. You're saying you're sued by a debt.
Yeah, by the
That's enrolled,
by
right?
Discover, yeah.
Yeah. And then did you bring this up to FDR?
I brought it up to FDR. They gave me a legal partner.
Uh-huh.
The legal partner, after reviewing the documents, or they were contacted and said, you know, we've been assigned to you. And they said they would get back to me in 48 hours. But it's been way more than 48 hours. It's been like 5-6 days already.
Oh, I see.
Yeah.
And then the deadline is in 5 days?
Yeah, the deadline is in 5 days.
Yeah, okay. So a lot of people who are in debt settlement programs end up using solo, especially, you know, if they get sued for debt. The biggest debt settlement firms have their own legal programs that like help them out in some way. It might be like a law firm that they own, might be a partner in a law firm. FDR has a partner in a law firm, and usually, I mean, some people still end up using solo suit. Oftentimes, the law firm should take it on for you. I mean, if you signed an engagement letter with the law firm, if you look through your documents, maybe you signed an engagement letter when you signed up with FDR. Maybe they're sending you one. Do you know? Did they say that they're going to send you a letter of engagement?
They said they were going to follow up and keep watching my spam, but they haven't seen anything to sign up or, you know, engagement, etc.
Uh,
We haven't gone further than the initial
yeah,
introduction.
lawyers, especially litigation lawyers, they're kind of operating on like the most intense schedule imaginable, probably. I don't
Yeah.
know how to do it. I don't know how you do it, Greg. I don't know how you do it.
I
But
I don't think I'll say this. I don't think I ever in my entire career have filed an answer before the date it was due.
for the date, right? You file it on the day it was due,
File
right?
it on the day it was due every single time.
Right. Yeah. So these guys, right? So these guys are probably going to file it on the day it's due.
I'm stressing, man. I'm stressing.
But here's what I would say.
Yeah.
Yeah.
The most likely scenario is they know the deadline and they're going to file it on the day that it's due, right?
Mhm.
So I would definitely be trying to get a hold of them to confirm that over the next 5 days, right? And if
Right.
you do and they say they're going to do it, great, fine. Let's assume that you don't get a hold of them and now it's the day that it's due. At that
Mhm.
point, I would probably be fine because I couldn't confirm that they were going to do it. Then I would probably file one myself. That's
Okay.
what I would do in your situation probably. Is
Yeah.
try and get a hold of them over the next 5 days. They're probably going to do it. If you can't get a hold of them by the due date, file it yourself.
Yeah. If you
So
had
it's
if
go
you had an
ahead.
engagement letter, if you had an engagement letter signed, I'd feel like very comfortable. I
Right.
wouldn't worry about it because then what that gives you is like the power to sue an attorney if they mess up, right?
Right.
So like they aren't going to mess up if they have an engagement letter signed. If you don't have an engagement letter signed of some sort with them, then maybe worry a little bit more. But like the reality for them is like they have 100 cases that are due today, so they're going to
Right.
file for those cases, right? Then they have 100 cases that are due tomorrow, they're going to file for those cases, and then when your case comes up, they're going to
Mhm.
file for that. That's
Mhm.
most likely the situation, right? And I mean, some people end up using solo suit still because a lot of like debt settlement firms, like you'll be paying monthly. I don't know if you are like aware of that, but you're probably paying like $5 a month or something for this legal plan.
It's probably in
And then
there
solo suit's
somewhere.
just like a one-time fee. Yeah.
Yeah. So
Yeah. What do you think?
if all things fail and Monday comes and this is D-Day, I just do something with solo suit at 9 a.m. to
Yeah, I
file it.
mean it's gonna be due depending on your state. The deadline is either gonna be 11:59 p.m. that night, or some states might have a deadline of like 5 p.m. So like
Mhm.
if Monday comes and you haven't heard anything, haven't been able to confirm, then I'd jump on solo suit,
Yeah.
put your answer together and get it filed that day.
Yeah, what I would do specifically is I'd use our AI document generator to create a motion to extend time, and I'd
Okay.
take that, and then I would would that work, Greg? I think that would work, yeah.
I mean,
Motion
it would. You could file a motion to extend the time, and the court would
on the
probably grant that and
on
give
the
you some
day
extra time.
on the last
Yeah,
day.
but that's not the safest approach, right? Because there's always a risk there. If you haven't gotten it decided before the deadline, there's always a risk that the court says, no, you don't get any extra time. And now the time's passed. I think the safest approach is it's not hard to prepare that answer on solo suit, right? I mean,
It's
what does
not
it
hard,
take? 30 minutes, maybe?
right. Totally.
So like
Okay.
do it on Monday morning. You could even do it in advance if you're like super nervous, and you
Right.
could
Yeah.
prepare it on Sunday and have it ready to file on Monday if they don't file
Right.
it.
Right. And the
Okay.
lawyers will probably thank you for it. Probably
All right.
glad
And
you did.
what's the worst case scenario there? You file one and they file one?
Yeah,
wow.
that's what I was wondering if there'd be a conflict and one throws out the other or one supersedes the other. I was worried.
The only conflict would be as if you admitted something in your answer that the lawyers deny, or vice versa. Then the court may say, well, this is admitted because
Right.
one of you has admitted it. But if you just file your answer and you take the approach of either I'm going to deny everything or I'm going to say I don't have enough information to admit or deny, then there's really not going to be a problem in
Right.
filing two answers.
Sean, what kind of
Understood.
debt situation are you in?
It was a loan from Discover.
How much debt are you dealing with altogether?
Total for that particular product is 24,900. Let's call it 25 even is owed right now.
Uh-huh.
It was a total of 35, but it's
Yeah.
now I paid down and it got to 25, and change in circumstances, so I wasn't able to make the payments.
Yeah. How'd you get into this situation of like a job loss or medical bills or
Over
something like
leveraged,
that?
and
Yeah.
the job being very seasonal, cyclical.
Okay. All right. Well, glad that Solo can help you get back on the right track. And thanks for calling into the Debt Hotline.
Okay, I appreciate the time, guys.
All right.
Good
Yeah.
luck.
Thank you.
Bye.
All right. We have another caller. We got Lisa calling in. Let's go ahead and plug in Lisa.
Hello.
Lisa, how's it going?
Doing good. How are you?
Doing good. Tell us about your situation.
Well, it's really my son's situation.
Mm-hmm.
He was sued for a debt from a bank that had to do with purchasing a vehicle. They sent copies of the documentation. Looks like it was an electronic signature. It's definitely not his. So we think it's fraud that's occurred. So we used Solo and we filed an answer to it, basically saying this appears to be fraud. Now we've received paperwork from their attorney stating a whole list of things that they're wanting. They're wanting text messages, email, Snapchat conversations. I mean, all kinds of stuff they've listed that they want in the next, I think we have 20 days left. And I'm like, I don't even know how to get all of that stuff, first of all. And my question is really, have they done their work before even filing this paperwork? These vehicles can be tracked now. They're saying they can't find it. Of course, if they can find it, they'll sell it and then they'll figure out what's left owing. But it really looks like fraud.
Right. Okay. How much is the lawsuit for?
I was looking for the paperwork earlier. I think he's got it up at his place, but it was like 40,000.
40,000. Yeah, that's quite a bit. Does he have other debts that he's dealing with as well?
No, just his regular living expenses, but he makes just enough to get by,
Nice. Right. And what state are you in?
Arkansas.
Okay, Arkansas. Cool. And so you got this. So your son got sued for a lawsuit for an alleged debt regarding a purchase of a car.
Yes.
Okay.
The way you've described it, it's not his car. Like, he did not buy the car.
Like, he's not driving this car?
We've
You
never
haven't
seen the car.
Okay.
He's never had possession of it. We knew nothing about this. It just kind of came out of the blue.
And like, you have a good relationship with your son? You don't think he has a secret car? Secret life somewhere?
No, he definitely doesn't.
Secret car that he only drives when he's in Texas or something? Okay.
He doesn't have the money to get to Texas.
Yeah, there you go. Greg, what's your take?
Okay, so I have a couple of thoughts here.
Mm-hmm.
The first thought, and this is going to be not like super common, but like relatively common, is that, and this is especially true, I don't know your son's name, but if he has a relatively common name, they may have just sued the wrong person, right? So like, if your name is John Smith, for example, they're trying to be like, we got to find John Smith and serve him. Maybe they've just served the wrong John Smith. So, that could be one scenario here, right?
Yeah, I don't think so, because the paperwork had his home address on it. Okay. Honestly, in my heart, I believe it's an ex-girlfriend.
Okay, so the next thing I was going to say is the other time I see this where it's relatively common, maybe not necessarily like boyfriend, girlfriend, but I see it a lot with like ex-spouses. Like in divorce, you'll see this where like the husband will take out a loan in the wife's name, something like that, right? So that's probably the more likely scenario. So I think you're right to defend this by saying, hey, this is fraud. The best thing I think that you can do in that case is to actually file a police report. The reason for this is, and I've had experience this where I've helped people, use like a fraud affirmative defense. You get into court and you say, hey, this is fraud. I think somebody has inappropriately used my information to buy this car. The judge is going to say, well, did you go to the police? And you're going to say no. It's like you thought somebody took out a loan in your name and you didn't tell the police about this. So and so if you go make a police report and then use the police report as evidence in your case, the judge is a lot more likely to believe you that this is fraud, because making a false police report is a crime, right? So it sort of bolsters your testimony in court, right? It makes the judge think, well, they're more likely telling the truth that this is fraud because they filed a police report, and people aren't likely to do that, because if it's false police report, it's a crime. So that's the number one thing I would do, is I would file a police report ASAP and then use that as evidence in the case, and continue to defend this as fraud. As far as the requests that they've sent you,
Yes.
I would respond to those and give them the information they are seeking. Now, I know people's gut reaction is like, this is my private personal information. I don't want to hand this over. But you are trying to not get a $40,000 judgment against you, or rather your son is, right? The best way to do that is to be very forthcoming and to hand over everything, so that you can say, look, there is no information here that indicates that I got this car loan, or that this was me, or that I have this car. So like, it's almost like the strategy is like an information dump. You can look at everything I have. This was not me. This was not my car. I'm not hiding anything here.
Gotcha. Yeah.
You know,
Now
and it's likely, to be honest with you, you can take the approach of like responding to those requests and just objecting and saying, I'm not going to give this. It is likely that the court at some point will make you do that if you want to move forward with defending the lawsuit anyway.
Okay.
So that's what I would do.
Could file the report and then reply to them by providing them with a copy of the police report.
Yep, that's exactly what I would do.
Awesome. I don't know how we go about filing that. Is that something?
Filing the police report? You're just going to look up.
Well, I know how we do the police report, but once we have the police report, then how do we file that? Do we have to file it at the courts in order?
So typically, you know, every court can be a little bit different, but for the most part, these discovery responses do not get filed with the court. You just send them to the other side, to the attorney. And so you're going to have to respond to all these things they're due in about 20 days. And so I would just copy of everything that you've got there. And so I would include a copy of the police report you make, and just include it and just mail it to the attorney. Do it certified mail, so you got a receipt that can verify that you sent it to them.
Okay.
Usually, you can check your court rules in Arkansas, but typically you don't actually file all those documents in the court. You just send them to the other side.
We just send them to their attorney. Okay. Yeah, and we're kind of thinking through our minds, you know, who could it be and where could that vehicle be? Because certainly if we can find the vehicle, we would love to let them know where it is.
Yep. I mean, look, you can take the approach of saying to the other attorney, I think it might be one of these people. Here are their addresses. You could like put them on the case. Kind of, you know what I mean? And I've done this before when you're defending like a woman whose husband left her and took out loans in her name. Like, we will go to them and say, hey, here's the husband's information. This is the person you're going to want to go after, and sort of, you know, send them off in that direction, and they do that work for you.
Yeah, because certainly they're wanting to try to find that vehicle so that they can sell it, which of course they're going to sell at a loss, but then someone's still going to be on the hook for the remaining loan amount.
Yeah.
You know, but that's a great idea. I'm going to have to sit down and talk to him and see who he figures out it might be. And then we'll get that police report filed, and then we'll just send everything certified mail to their attorney.
Yep.
Awesome. Thank you so much. This has been so helpful.
Thank you, Lisa. Thanks for calling in.
Thank you. Have a good evening.
You too.
Great. Then we have another caller, Bruce, that we're going to get to in just 1 second. Greg, for the identity theft situation, right? Yeah. So filing the police report is key. You're saying you think maybe an ex-girlfriend bought the vehicle out of spite, right? To get back at him? Is that what we're saying? after they broke up?
What I have commonly seen, and again, this is more common when like with a divorce, it's not necessarily spite. I mean, I think it really is like, in a lot of times it's fraud, right? It's I'll go take out a loan or get a credit card in my ex-wife's name and spend it, and then I'm not going to have to be the one that pays it back because it's in her name.
Right.
And they'll go after her and they won't come after me. And so
Right.
if that happens to you, if you've got an ex that has taken out a loan in your name or run up a credit card in your name, now the onus is really on you to flip the tables on them.
Right. Yeah, it's vindictive behavior, right?
It is. Yeah.
Could the ex-girlfriend really? I can imagine the ex-girlfriend buying. That's not that hard. You can buy a car on a credit card. Probably don't need hardly any information about the credit card owner. How she couldn't register the car in his name, right? That'd be registering the card
No,
in
it's
his name. Would that be
probably
hard, or would that be pretty
what
easy?
it's probably done is gone to this bank and got a private loan in her boyfriend's name.
Right.
And then used that money to buy the car. The car's still going to have to be purchased by her, registered by her.
Right. Yeah. And so
it probably was just the loan. It's probably a private loan that was taken.
Right. So my other thought, I wonder if Lisa couldn't hire a private investigator to find out who owns the vehicle, right?
Sure.
To own the license number.
Yes. And this is what I was going to. She could do that herself. What I like to do is that collector wants to find the car. They're more incentivized to find the car than you are.
That's the collateral, right? That's the collateral.
And so what I do is I'm going to call up that attorney and say, look, I know you don't believe me that this is identity theft. That's fine. I'm still going to defend myself that way. But I'm telling you, I bet you I know where the car is. And here's the person who I think has it. You go hire the private investigator.
Right. And I would bet that case with Lisa is probably with a smaller collector or law firm. Is what I bet. It's probably not with like a big machine debt collector. All right.
Yeah.
Folks, if you have questions, you can call into 801-613-8181. We're pretty much, this is going to be our last caller for tonight, but you can call and leave a voicemail for tomorrow or for the next time, or just call next time. All right, Bruce, we're going to plug you in.
All right.
Oh, Bruce,
Hello?
how's it going? Hello.
Good. How are you?
You're good. Tell us about your situation.
Well, I've got a debt, a credit card debt, and it's been over 5 years that I had it. And then they sued me at 5 years and like 1 month. They said that I made a payment on it within that past year. So, and I never had. So I went ahead and filed an answer. And in the answer, I said it's time barred, and that I don't know what else I put in there. And then I went to court, and I was the only one in there, and they had 15 other people on the computer. All the attorneys were all logged in, and it got to me, and they said the attorney, I don't know, said something, he wanted to extend it, and the judge looked at me, and I could have sworn she said something like, you need to file a motion to dismiss. At least that's my wife said, she said, and they extended it for another year. So I never even got to present anything to them, showing that it's time barred. I have my bank statements and credit card statements showing that I didn't make a payment within that 4-year period. And I never submitted that, but I have the paperwork and stuff showing that I didn't owe it, or that it had been passed. And they asked me if I wanted to talk to this attorney regarding the debt. And I didn't want to, because I would be afraid that would be admitting that you owe the debt. So, and that would reset the clock. But so now I have to go back next September, and I'm wondering, should I file a motion to dismiss, showing that it's time barred again?
Yeah, tell us what state you're dealing in.
California.
So it's California. How much is the debt?
$17,000.
$17,000. It's a credit card debt.
Yes.
Yep. So you're in this courtroom, and everyone else has been like calling in on Zoom. You're in person.
Yes, all the lawyers were calling in, and nobody else showed up in the courtroom as to answer. They were defaulting left and right. And then it got to me.
Default.
Right. Yeah. And then it got to me, and I was there, and he said, well, I don't remember. I should have listened harder. I was really nervous.
Was he like up on a TV or something?
Yes,
like on a
yes,
TV?
they had him on behind the judge on a big, huge old 12-foot screen, and he popped up and he said something like, "I don't have stuff ready." I guess he probably wasn't aware that I would be showing up. It was for LVNV, and she goes, "Okay, well," and she asked me, "Is it okay for us to extend it?" And I said, "Well, yeah, but I kind of wanted to get it over right then." And so they extended it 1 whole year, so it'll be this September in 9 months to show back up. And I've been doing it online with.
And like the judge like whispered to you, like file a motion to extend.
She said something like, "Well, you can't do anything right now because it's been extended, but I would." Oh, what did she say? My wife said, "Oh yeah," she said something about motion to dismiss. In order for something to happen, it has to be dismissed. But she was seemed like she was a little perturbed at the guy calling in, like, it had been 6 months or so since I got the person showing up at my door saying you're being sued, and then it seemed like he didn't have his ducks in line or something was not ready, and so he just extend. And he had other people; they were all defaulting, and he went all with them. But me, he saw me there, and I had to come up and sit there, and then he goes, "Oh well, I need to extend this," and I think it was after he got off. She said something about you need to. Yeah, she didn't actually give me advice, but something came up of something needs to be. You need to file for. I thought it was a motion to dismiss.
Motion to dismiss. That's what I meant to say. Yeah. Motion to dismiss. That's probably what I should whisper to you. Well, congrats on getting off to the first step and filing your answer, then showing up. That's a great move. An example to all of us.
A motion to dismiss. There's a bunch of different ones. One's if you brought the lawsuit against somebody, there's a certain motion, and then the other one is if you're being sued, there's a different form that you have to file.
Greg can help clarify that. Greg, you want to go ahead?
Yeah. So I think that's what you do want to do is, you could wait until that hearing in September and make your arguments then.
And show the proof that I have the paperwork showing I didn't make a payment.
Yeah, but I think where the judge is getting at is like, look, she can probably get to this sooner if you file the motion to dismiss. So use the form. I know California has a lot of forms that are pre-made for people. So use the one for a person that has been sued.
Right.
And in that motion, you want to show, hey, here's the citation to the part of the California Civil Code that says that 5 years is the statute of limitations.
Right.
And then you are going to want to lay out your facts, and I would attach a copy of all your statements. Obviously you might want to like white out or black out bank account numbers or something like that, since you're going to be filing this stuff with the court. But you want to attach all your proof and show basically like, look, you can see right here, here's the proof that it's over 5 years, and file that motion. They've got to then respond to that. If they don't respond to that, the court can automatically grant your motion to dismiss, or they can respond and try and make the case why they think it's not time barred.
Right. So when I file the motion to dismiss, I attach other paperwork giving them evidence that I didn't pay anything. Yep. That it was closed. Okay, good. All right. And then then hopefully if they have an answer for that, they'll tell me not to show up in September, right?
If the case gets dismissed, the hearing in September will get canceled.
Okay. All right. Good.
Also,
I'll do that.
A couple other thoughts here for you, Bruce. Yeah, so maybe you're thinking about the motion for summary judgment, right? So you have a motion for summary judgment, motion for dismiss. Motion for summary judgment is like what somebody filed after a complaint is filed, after an answer is filed. Someone can say motion for summary judgment. That's basically like that's you asking to win the case. Like the judge should just say you win the case, basically, because the other side doesn't have an argument. And then you have a motion to dismiss. That's saying you're asking the judge not necessarily to say that you win, but you're asking the judge to just kick the case out of court. So it's a little bit different from like straight up winning the case, but pretty much
you could in his case he could actually file either motion. Either motion should work.
Okay.
So limitations, you can get it dismissed, or you can do it summary judgment. Either kind of motion should work.
If you're feeling really confident in your position, then a motion for summary judgment is a stronger verdict. It's like a stronger position for you, because that means you don't owe the debt.
You win.
Right.
Okay.
Right. And like I'm pretty sure like the collector wouldn't have any. It you probably have a case against the collector if they try to collect on the debt at all after
Well, in
that.
California, if you file a judgment that is time barred, it's $1,000 fine. From what I've read.
Then
At least
file the motion for summary judgment and get that. If you win that, you get that judgment. Now you've got a claim for $1,000 against them.
Now you're making money.
Right. Okay.
So the other thought here is a motion in the most basic sense of just asking the judge to do something, right?
Right.
You can say motion to do anything, right? Like motion to just like whatever, right? Like motion to say my name in court. You could, and you also don't actually have to technically in most situations you don't have to even file a document. You can actually just do a verbal motion. Is that right? Is that right, Greg?
So if you're
could you get away with a verbal motion? Like this rewinding to Bruce in court, could he actually have just done like
standing there in
move
court,
to dismiss?
you can make a verbal motion. Typically, motions for summary judgment are not made verbally because there's certain protections for someone who is defending against a motion for summary judgment. They have certain time and certain evidentiary things they can do. So you can make a motion in court. The best way to do this kind of a motion is to file it.
Okay.
What about a motion to dismiss? Like, wouldn't it have been, if you were there, you would have just asked to dismiss the case right there, right? You would have asked the judge.
You could have done that, yeah.
Right.
Mm-hmm.
Yeah.
Wow.
So I think that's a point that a lot of consumers miss, is that when you show up in court, your first, if you're in that situation, your first move can be just to ask the judge to dismiss the case, right? Like say, hey, I'd like to move to dismiss the case, like right now.
You got
to have your evidence. Boom.
But if you've got to have your evidence, I think a lot of people just show up and be like, I'm asking to dismiss the case. And the judge says, okay, why?
Right.
You got to have a reason why.
You gotta have a good reason, right? Yep.
Right.
Okay. Well, that sounds good, Bruce. And that sounds good. You know, just for people listening, right? If you're in a situation like where you owe the debt, statute of limitations isn't expired, Solo takes position. You know, best option for you is just to get the case settled. You know, pay back the debt at a discount to the collector. Sounds like you're in the situation where you're not in that situation. You have like a statute of limitations situation where collectors really don't want to collect. I mean, if the statute of limitations expired, then that's where you're at, and you should not need to. You should just get this resolved without paying, and just get it resolved out of court. All right, Bruce, that sounds good. Thanks for calling in.
Thank you. Bye-bye.
Thank you. Take care. All righty, folks. That is it for the Debt Hotline today. Greg, thanks so much for coming on, and thanks everybody for listening in. We dropped a link in the chat if you have been sued for debt, or if you have a debt that you want to resolve. You can just click on this link. I'll put it into the chat again for you. Just click on that link, go over to Solo, and get it fully resolved, and I'll support Greg for coming on to the show as well. Thanks a lot.